this is the beginning of our seminar for Spring 2020 module of Fight Against Corruption. And this is third in a series of our seminars. Today you kindly agreed to hold this seminar on Saturday, which I appreciate very much. We have only one participant, but this doesn't keep us from conducting this seminar. Farid, I haven't provided questions in beforehand, just deliberately, in order to see how you're going to be able to answer my questions and to check how you understood the material, okay? As you know, the topics are related and identified in our lecture 8 and 9, and we spoke about criminalization of corruption offenses, right? In the broad topics, in the broad range of topics. If you don't mind, I will ask you a question. The criteria for evaluation is that you need to be able to demonstrate your understanding. This is like a basis. Then you need to be able to go into details of the problem and easily navigate among these details. Then you need to be able, in order to get high mark, you need to be able to explain give your critical view on the positive and negative sides, on advantages and disadvantages of a problem. Okay? Are you following me?
Yes.
Yes, okay. It may sound scary, but all you need to show me that you understood it well. Okay, my question is about these newly added sections in the penal code. Okay? Can you tell me which these sections am I talking about? There are traditional corruption offenses, right? And there are these newly added specific offenses.
Okay. New offenses in our criminal code is 12 offenses is included in our criminal code in 2016 years. The offenses is reflected in 308-1 article and 308-2 article. One of the new offenses reflected in our criminal code is diversion of public funds and full name of crime, diverted of use of budget, and also special public revenue funds and extra budgetary fund. The offenses is new for our criminal code, and the offenses, there are main elements of offenses are included: mens rea and actus reus. Mens rea is subjective element of offenses, and guilt of form is included to a subjective element, and this crime is committed is committed intentionally or only direct intentional. And the next element is crime is actus reus. Actus reus, the first element of this crime is perpetrator. Perpetrator is of this crime is public official, and the next element incentive element. But incentive element and also the next element beneficiary element is not necessary element, because it doesn't need to be shown. And the next element of this crime consequence, and also this crime is material crimes, because the person has a criminal liability for this crime when this crime acts, including this version of this crime, result in a large amount, and large amount means from 50,000 manat to 150,000 manat, and also aggravating form of this crime is reflected in 2308 article dash 1.2, and this and crime result in great large amount. Great large amount means is more than 50 to 150,000 manat, and the next crime is also new for criminal our penal code. The crime is reflected in the article 380 dash 2. The crime is called breaking public procurement rules. These crimes, the main element of crimes are included mens rea and actus reus. Mens rea is a subjective element of this crime. This crime is committed by intentionally as previous crime, and the next element in this crime is actus reus. Actus reus, the first element of perpetrator. Perpetrator of this crime is a public official. As the previous crimes, beneficiary element and also incentive element is not necessary, and it doesn't need to be shown. And the next element of this crime, behavior, including failure to follow the rules or bending the rules. And the next element, consequence of this crime. Consequence results in a large amount, and also great large amount. Large amount means from 50,000 manat to 250 manat, and great large amount means is more than 250,000 manat.
Farid,
Also, this crime is a material crime.
Okay, your camera is switched off again. If you can please switch it on back, please. You picked this topic of additional sections 308 dash, right? 308 dash 1 and 308 dash 2, which were introduced into the penal code with the interval of 1 year, correct? And you just told me about these differences between these between these sections. So these sections are about these public procurement rule violations, right?
Yes.
What are they? Can you give me the title of these sections?
Also, I'd like to add this crime is not reflected in the United Nations Convention against Corruption.
Okay, so you actually started to answer the question which I haven't asked, but which I was going to ask. So this the peculiarity of these crimes is that they are not foreseen in the United Nations Convention against Corruption. But can you tell me which crime are they resembling? Which corruption offences, which are foreseen by the United Nations Convention, are they similar to? How they are similar to these offences? Did you understand my question?
Yes.
Please go ahead.
I think abuse of function, I think, is similar to new crimes, and also I think illicit enrichment is similar to new crime.
Okay, tell me, has Azerbaijan criminalized illicit enrichment?
No.
No. Okay.
This crime is only.
Okay, I was worried that maybe you think this way. Okay, correct. It wasn't. It wasn't criminalized illicit enrichment.
Yes.
Can you tell me how are they similar? These new offences, 308 dash, right? Let's just call them generally. Generally, these two articles as 308 dash. Okay, how are these offences provided by section 308 dash are similar and different from the offence of abuse of office, which is foreseen by section PC section 308? What are similarities and difficulties? Actually, you demonstrated your knowledge of this topic. You went into details. So now you need to provide these critical views of yours in order to get high mark. Okay?
Okay.
Go ahead.
The first similarities of abuse of power and diversion of public funds, also breaking public procurement rules, is this crime, the mens rea, because these crimes are committed intentionally, also directly intentionally. The next similarities of this crime is a perpetrator. Perpetrator of this crime is public official, and also public official, and there also action is inaction is the main element, the similarities of this crime, and also there are differences of this crime. I think the first differences of this crime. Consequence. I can't remember. The next similarities of this crime is material crimes, because the person has criminal liability for this crime when the action, including disposition of crime, result in consequence. But I think the differences of this crime is including including disposition of section. I think the act is more the act abuse of power is more larger than new crime reflected in our criminal code. And also the next differences of this crime consequence, because the abuse of power consequence means inflicted damage to rights of physical person, interest of legal person, and protect the statutory interest of society and also state. But the new crimes consequence means consequence means a large amount, and great amount means from means 50,000 manat to 250,000 manat.
Okay, the consequence. You actually started on a very shaky ground, but then you continued and you started to produce the specific answers, which is good, which is very good. You mentioned several criteria, how they are different. Okay, they are similar in nature, these offenses, right?
Yes.
The similarity in nature is that there's an intention, right? Perpetration by public official or official. Also the similarities between these offenses is that they are conducted through the violation of laws, right?
Then also the next difference of this crime, abuse of power incentive element is necessary element, including undue advantage, but new crime is not necessarily.
Excellent.
Element.
Very good. Very good. So the thing is, the legislator demanded that the violation, if the prosecution goes after an official under section 308, then the prosecution must demonstrate not only the violation of laws, right, which is similar between these offenses, a similar feature, but in case of abuse of office, right, prosecution must demonstrate, and when I say prosecution, I mean generally investigation and prosecution, right? Prosecution needs to demonstrate that as a result of this violation of law, damage was inflicted, as you mentioned correctly, to the rights of people, to the interests of legal persons, as well as legally protected interests of society and state. This is the formula. This is how these objects are described in the penal code. So in the case of PC section 308, a legislator demands that the prosecution demonstrate illegal action causally linked to the inflicted damage. So we have these three crucial elements which exist in abuse of office, but they don't exist in these 308- offenses, right? So in this case, are you following me?
Yes.
Okay, so in this case, this damage must be demonstrated, this illegal action and this causal link between these two must be demonstrated. Three criteria. Whereas in the case of 308- crimes, right, all the prosecution needs to demonstrate is the violation of laws. The violation of laws, that this public procurement was conducted in violation or without public procurement procedures, right? And they don't need to, they just need to demonstrate the amount of the property which was subject to this offense. Correct?
Yes.
Okay. Very good. It's very good that you managed to capture these differences between these offenses. I think when and if you practice criminal law in the future, you will go into more details and you will understand it in practice, but theoretically you understand this topic now and it will be quite useful for you. Let me now switch to another question. And I think today we have six. I had 6 questions in mind, which I already posted with your Microsoft Teams class in this section of class materials. You can see these questions. The second question, overall there are 6 questions, but I'm going to ask you today only 2 questions. The second question is about these 2 offenses. One is excess of office, right?
Okay.
Which section is it?
309.
Correct. And the other one is assuming the powers of a official, which in a sense in the other countries this offense is also called as identity theft, right? It partly covers this offense, which is in PC section 310, okay? 310. Can you briefly tell me, very briefly, about these crimes? Can you just dissect them for me?
Okay. The first crime of excess of power. This crime is reflected in the 309th section of our penal code. The main element of this crime, as other crimes, is objective element and subjective element. The subjective element of this excess of power are included mens rea, included a guilty form of guilty. This crime is committed by only intentionally and directly or indirectly. Intentionally, the next element of this crime is actus reus, and perpetrator is one element of actus reus. Perpetrator of this crime is only a public official, and the next element is incentive element and beneficiary. But incentive element and beneficiary is not element of this crime because it doesn't need to be established in the crimes, and behavior included of this crime action, and also the act included the excess of power is based on Soviet Supreme Court decision dated 1990. In accordance with this decision, the act including excess of power are following. Public official is acting, but the act does not belong him. The act belongs to other public official. Also, the next act, public official acting in ordinary times, but the act must be done by public official in special times, and public official is acting, but the act must be adopted. To the act must be adopted by collegial organ, a collective organ, and also the public official is acting, but the public official must never act, also has no right to act. And the next element of this crimes consequence. Consequence is main element of this crime, and these crimes are also is material crimes, and a consequence the rights are included, the rights of damage inflicting the rights of physical persons, the inflicting damage to interest of legal person, and also protect the statutory interest of state and society.
Okay, you just mentioned the decision of the plenary board of the Supreme Court of the the Union of Soviet Socialist Republics, which was issued in 1990. I'm glad that you went into deeper research in this area and you studied additional materials for our class. And you mentioned this decision is still effective, of course. You mentioned different types of committing of this offense. And you mentioned one which says that when public official is doing something which does not belong to his competence, but it's a competence of another person. Can you draw me a difference then in which case his action will be, because it is actually similar to another offense. It's similar to another offense, which is fraud by public official. It's also exactly when a person is doing something which doesn't belong to his power, right? It belongs to the power of another public person, public official. So can you differentiate, can you give me examples when in such scenarios the case will be qualified as an offense of excessive office, and in which case it will be qualified as an offense of fraud by public official?
Fraud by public official, differences?
Do you remember? Yes, because they're just very similar with the what you just mentioned. When a public official is doing
of these crimes is first actus mens rea.
No, I'm not asking you to describe to me the similarities between fraud by public official and excess of office. You gave specific example, okay? You gave example that if a public official is doing something which is not his duty but duty of another official, correct? You gave me this example.
Yes.
You mentioned this example from the decision of the plenary board of the Supreme Court in year 1990.
For example, I think the public official signs any documents, but they has no right to sign this document.
Okay, I understand this example. Okay, well, let's imagine there's a ministry which issues license. Okay, and in order to issue license, the Directorate of Licensing, the manager of the Directorate on Licenses must give his signature, correct? And it is, let's say, head of Human Resources Department, which in his stead, he's signing this license, the document supporting license, right? This would be excess of office, correct?
Yes.
But it also can be similar to the offense of fraud by public official. What kind of crime is this, fraud by public official? It's a crime against the subject matter of fraud by public official is property, isn't it? Yes. Property. So when a public official wants to get hold of property by means of deceit or abuse of a trust.
Abuse of trust.
Yes.
Also, these crimes is not considered as corruption offences. Is against property in our criminal code. But in the United Nations Commission Against Corruption, this crimes is considered as corruption offences.
A fraud, you mean, by public official? Well, imagine. Okay. Imagine, can you give me an example? Well, let me tell you. The question which I'm asking is actually not related to our today's seminar, but to our previous topic. But I want to make sure that you understand this difference when similar set of actions, similar in many aspects, but different in some aspects, some tiny aspects, they can be differentiated between official fraud by public official and excess of office. But before going into that area, can you tell me the difference between the offense of excess of office and abuse of power? What is the difference between these two topics?
Excess of office and abuse of power.
Yes.
I think differences. The first differences of these crimes, I can remember, just a minute. The main element of this crime. Aggravating forms is differences of crimes is differences because abuse of power. Aggravating form, one of the aggravating forms is grave consequence.
Okay.
But grave consequence means I think.
But let's not touch the aggravated forms. Okay, let's not touch. Let's speak about the basic offenses of.
Well, aggravated consequence means a death of person, also violation of.
But what is the difference between 308 and 309? What is the difference? Main difference.
differences of yes, incentive element next differences,
Okay.
because abuse of power incentive element is undue advantage, but the other crime is not element, because it does not need to be established, and
It
also a
doesn't. Well,
beneficiary
one thing.
element.
Let me interrupt you, Farid. When we say it doesn't need to be established, it doesn't mean that investigator or prosecutor here can ignore this, okay? It all depends on the factual circumstances that investigator or prosecutor actually is capable of establishing. Do you understand me?
Yes.
So in case if investigator and prosecutor is capable, if he can establish, are you still with me?
Yes.
Okay, if he can establish this, if he collects enough evidence, right?
Yes.
That he can prove the incentive element, this undue advantage element, in that case, he will go after this criminal, he or she, the prosecutor will go after this criminal perpetrator under section 308. But if he's not capable, I mean, it may exist in reality and prosecutor still not being able to prove it, but there also could be a scenario where it doesn't exist. So there is no incentive. Okay, so the main difference between these two offenses is this undue advantage element, right? It's a crucial
Also
difference.
beneficiary element, the next, and abuse of power for to obtain advantage for himself or other person entity, but access of power, there is not element, because it doesn't need to be established.
Okay, then we switch back to the previous question. In the case of public official fraud, right, the main task, the main purpose of this offense is get hold of property, right?
Yes, abuse of trust.
In the case of fraud or fraud by public official. So the public official is committing fraud, this specific offense, when he wants to get hold of property. Whereas in the case of the excess of office, right, even if he's doing something not belonging to his duties, right, to his competence, his task is not to get hold of property. In the case of excess of office, correct?
Yes.
Are we on the same page?
Yes.
Okay. So it's really important that you know these subtle differences in the case, especially in the future, when and if you decide to practice criminal law. Well, Farid, you have answered very well today. I'm content with your answers. There are, of course, rooms. There is a room for improvement. There's a room for improvement, but overall, I'm very content. You demonstrated very good knowledge of the topic. I would like to allow you some time, just in case if you have questions. If you have any questions relating to this topic, do you have any?
Do you have any related corruption offenses?
Yes, to today's topic, because just in case if there is some question that still remains which you didn't understand from from the lectures and materials which you read.
I have taking option of power of option.
Say again, please.
Taking power of option.
Okay. Assuming power of a public official, right? Section 310. Yes. So what's your question?
I mean the question in English, because I can't find the meaning of English. Can I ask a question in
Okay,
Azerbaijan.
I'll help you to translate, to interpret it into English. Say it.
Bitmiştir.
Bitmiştir.
Bitməmişdir. Onu necə fərqləndirə bilərik? Yəni,
Okay, your question is about attempt. Okay,
Yes.
Jahd is attempt. You're asking when can we determine that when the attempt was accomplished into a complete offense, right? Where's the
Yes.
difference between attempted, assuming of powers of public official, and where it is the end?
Yes.
Okay. So let me not answer you directly, but let me coach you, help you to arrive at correct answer. Okay. First of all, tell me, when does legislation provide for liability in the case of attempted offenses? Does the liability for attempted offenses exist in all 4 categories of crimes?
Yes.
Yes?
4 categories crimes, attempt. The attempt of crimes is possible when the crimes is committed intentionally.
Okay. Okay. So,
Hazırlıq o ingiliscə necə gedir?
preparation for the crime.
Okay, the preparation of the crime is possible when crimes committed by when crimes is serious crimes and special serious crimes.
Okay, so that's a difference, okay, between attempt
Yes.
and preparation for the crime.
Of crimes.
Okay, your question wasn't about preparation, but it was about attempt.
Yes.
When is the offense of attempt important? I mean, when does it come into play? When the crime is about consequences, ensuing consequences, or when the crime is about the action itself, right? In our legislation, we differentiate between the so-called formal offenses, right, and material offenses.
Yes.
Material offenses is all about ensuing consequences. And formal offense, right, it's about the action itself. So, tell me, this offense of provided by section 310, is it material offense or is it formal offense?
Material offense.
And what are the consequences when which are foreseen?
Yes, the main element, consequence, inflicting damage to the rights of persons and interest of legal person.
Okay, now answer me the question which you asked me, okay? So when can we draw the line between an attempted, assuming of powers of official, and the actually accomplished or finished offense of the assuming of powers of official? Once you identify that this is a material crime, and in order to prosecute fully for this crime, there must be consequences established. So, can you tell me now, answering your own question, when can we draw this line?
I have some problem.
Okay, I noticed that. You're back. So, can you make a difference yourself? Give me an example of the excess of the assuming of powers of official.
Sorry?
Can you give me a hypothetical case?
Okay.
Example. Can you imagine a case of this offense? Okay, let's imagine. Hello?
I can hear you.
Okay, go ahead. Can you hear me, Farid?
Yes, yes.
Okay. Can you give me an example of the assuming of powers of public official? Is there any element of undue advantage which needs to be proved?
Yes.
Undue advantage.
Undue advantage is not proved in
Doesn't need to be
excessive
proved,
power.
okay?
It does because it's not it is not element of this crime. It does need to be established in excessive power. Hello.
So tell me.
Can you hear me?
Yes, of course.
This element is not.
Okay, let me give you an example.
element.
Okay, let me give you an example.
Example.
Yes.
Just a minute. Money, loans, for example, sexual favor.
No. Example of the assuming of powers of public official.
Powers of official.
Yes. Let me give you an example, okay? Imagine a security guy in a building.
Yes.
Security guy, okay?
I can't hear you because I have.
Can you hear me now?
Internet problems.
Can you hear me
Yes.
now? Okay, I can.
Yes.
Maybe because you have video on, that's why the connection is poor. Maybe you switch off your video and it will get better. Okay? How is it now?
Okay, I can hear.
Okay,
yes.
Imagine a situation when a security guard, he is stopping someone and start to conduct search, presuming that this person he stole something, for example, and then locks him down in a room. Can you hear me?
Hello.
Oh, I think we have problems, right? Hello? Hello?
I can hear you now.
Okay. Tell me, the security guard is conducting some sort of the police activities, okay?
Yes.
Police activities. Hello?
I can hear you.
Okay. What are the consequences that need to take place in order to be to prosecute that person for the assuming the powers of public official?
Inflicted damage to rights of person.
Okay. How can this damage could be demonstrated?
Hello.
How can it be demonstrated?
Hello. Hello.
Hello, can you hear me?
Yes, now I hear you.
Okay. How can we demonstrate that this happened?
I think it's proved. Damage is proved by is proved in these cases inflict damage to rights of persons. Also.
Okay, so if we can prove that the actual damage has happened, in that case, this is an accomplished offense of assuming powers of public official in this specific case. But if we can show that this person, he attempted to do some actions, but actual consequences, they didn't happen, in that case, that will be an attempted offense. Did you hear me?
Yes, but I have some internet problems.
Okay,
connection
Farid,
problems.
I see that you have problems. Maybe at this point we just finish our seminar.
Yes.
Thank you very much for your very active participation and for your preparation. I will reflect the marks in our software in Microsoft Teams. And please follow my lectures and see you next time, okay?
Okay. See you.
Bye-bye.
Bye.